So this is a dog bite case that gets pretty interesting. It's been going on for more than a year and has some interesting legal entanglements that have been tying it up, as well as a demand for a jury trial. So this is Miss McSwain, our defendant. She shows up for a second, then disappears and lets her attorney handle everything, which is good because she missed several hearings in the past. At least she showed up for this one. She likes dogs, but she doesn't like following the rules regarding her dogs. This dates back to June of 2022, when she received citations from the city of Detroit for allowing a dog to stray in a public-private property without a leash, failure to vaccinate, and not having a license for her animal. Then, on 10/13 of 2022, failure to register the animal, failure to vaccinate, and failure to prevent the animal from engaging in nuisance or menacing behavior, which generally means that the dog was aggressive towards someone. Several days later, on the 20th, she received citations for harboring a vicious animal, 2 of those, failure to surrender an animal for rabies observation after a bite, and harboring 2 or more animals over the age of 4 months. Those October citations are what we are here for. As you can see, there have been quite a few hearings on this case already, and there is actually a jury trial scheduled for February of next year. But we have 2 motion hearings before that, so here we go.
Attorney Dunn, this is the most, where are we?
Judge, we'll take your February jury trial date.
February jury trial date, all right.
So are we still having a motion hearing on the 26th?
Yeah, I'm sure we are. We're still all set for the 26th for the motion, correct?
Correct.
I don't understand what the motion would be. My client gets a hearing and we're setting it for the February date. I don't understand what would be.
Actually, I thought there were some things that wanted to be worked out with regard to your client testifying or speaking at the hearing prior to trial, and whatever he testified to at that hearing, he would not be held against him at a trial, or some things that we were discussing earlier. So I'm not sure where we are now. If you said,
well, okay, Judge, I'm sorry. This is how I understood it. That Miss Rogers and I would work out an order. I suggested the language in the civil forfeiture 7 MCL 75050. If we can't work that language out, we have enough time to file a motion to have you resolve it or settle that order or that issue. And then we would just need new witness list, exhibit list, exchange dates. She's getting her hearing to euthanize the dog. It would be in February in front of a jury.
But no, counsel. So this is it's a motion, it's an evidentiary hearing. It's a question of law. If it's risen to a dangerous dog level, that should be determined by a judge. There's no right to a jury and for this. We're looking if the dog is dangerous and if it should be euthanized. Of course, the underlining criminal matters that are all misdemeanors, of course, there's a right to a jury on that, and we can do that in February. But the hearing regarding the dog being dangerous, there's no right to a jury on that. The judge needs to decide that per the ordinance.
Well, this is the problem, Judge, is the way the city does these is they don't file a civil action. They're doing them within criminal cases. And this is a criminal case. It's in a criminal case number. My client gets a right to a jury.
So
But
there's
not
2
on a
different
motion.
things. Hold on. No. There's 2 different things. Your client has a right to a trial regarding her criminality. She does not have a right to make a determination if the dog should be euthanized. That is not a criminal case there. The criminal case, she has a right to a trial for. The determination if the dog is dangerous is not a criminal matter. That is a hearing that's going to make a determination where I get to make a determination if the dog is dangerous or not. The dog doesn't have a right to a jury trial.
Okay, then Your Honor, then the 26th would be the evidentiary hearing or trial of whether the dog should be deemed dangerous.
Yes.
Okay.
Yes. And then, and your jury, wait a minute. So, okay, now I'm getting my dates confused because we're bouncing around here. So, all right. The evidentiary hearing was going to be on what date, madam? prosecutor. And we'll see if we agree with that based on, this is, the evidentiary hearing was what date we talked about?
October 26th, Your Honor, in person.
Yes, October 26th. And then we talked about a jury date on February the 29th for Ms. McSwain, correct?
Correct, Judge.
All right. Now, are we clear what we're doing on each date?
It is, Your Honor. I just want to make the record clear then, just for any appellate purposes, that when I said you're right on the February jury trial date, I was requesting that my client have a jury trial for the dangerous dog determination, and you've ruled no. You're going to do it.
Well, those are two different determinations, because that is not a jury trial.
Understood. I just want to make sure that it's clear I wasn't agreeing with you, with all due respect.
Okay, all right. Now, with our jury trial date, we always have a week before that jury trial date, a pre-trial date of February the 22nd. And we do that to make sure that everything is set. The jury has been notified. We're going to be here and we're going to be ready. So that's just a final check to make sure that on jury trial date, we don't have a snafu and juries aren't going to be here and things like that, or we don't have enough jurors or something of that nature. So we do that the week before at 9 or 8:30, Madam Clerk.
The final pretrial is at 9 o'clock.
At 9 o'clock. So on February the 22nd, we'll have our final pretrial, which is the pretrial before a jury trial date at 9 o'clock. And that's just to ensure we're all set.
Okay, got it, Judge.
On Zoom.
What you say, Madam Clerk?
Final trial is on Zoom.
Oh, yeah. Yeah, our jury trial is going to be obviously in person. The final pretrial is on Zoom, just to ensure that we're all set.
Thank you, Judge.
Thank you.
Yes, thank you, Judge. See everyone on the 26th.
All right. All right, this matter is adjourned.
Thank you. And Ms.
Thank you.
Rogers, are you around this afternoon for us to coordinate maybe some language or even?
I am. Feel free to give me a call anytime after 1:30.
Perfect. Thank you. Thank you, Your Honor.
Thanks.
Thank you, Ms. Clark.
Thank you.
And then we come to our most recent hearing, and this is where things get interesting.
So, do I have these? All right. I guess I am totally confused with this defendant India McSwain case. Is this, I mean,
Your reporter might need a break
Oh.
before you get started.
I'm fine. Thank you.
Oh,
oh, I know. We got, all right, this is parties are joining. Okay. All right, let's see, what do we have today? Well, let's call this case. This is case number V128881822OM. City of Detroit. Wait a minute, is Ms. Rogers? Yes, Ms. Rogers is out here. The City of Detroit is the plaintiff. Defendant is India McSwain, who is represented by Miss Celeste Dunn, Esquire. Then I have something else that just came before us. Intervening party motion. This is obviously the same case number. We now have the attorney, an intervening party attorney. Is that David Draper?
That's right, Your Honor. I'm David Draper. I represent the proposed intervener. His name is Author Jackson. There might be a misspelling there, but it's Author as traditionally spelled, I believe, AUTHOR Jackson. He's not here today. Go ahead. I'm sorry.
All right. Yeah, he has an additional R in it. He has
Sorry about that.
AURT. That's not a problem. AUTHOR. Okay.
So, Judge, I
All right.
know it's a little confusing. If you want to let me go, I'll talk. If you have questions, whatever your pleasure.
Oh, I need you to definitely talk, and because yes, I am very confused at this point.
Okay. So essentially what we've got dog Crunch. Crunch is the dog. There's a criminal case with wife.
Hold on, counsel.
Yeah.
I do need your appearance and P number on the record.
Sorry, David Draper, P43750. I'm representing proposed intervenor or author Jackson with his consent.
Okay, just so I understand, it's author Jackson, who was somebody who claims to be a co-owner of the dog Crunch?
You've got it. I don't think it's gonna be that confusing, Judge. He's
Still
the
gonna be that
husband.
confusing because this has been ongoing now for months and months, and
I
now
know.
I'm hearing there's somebody else who has an interest in this case and the dog. So
Right, so he's married to India McSwain, and she's the lead, or the only defendant in City of Detroit versus India McSwain, the case we're here under. So essentially, this has to do with a bite by dog Crunch. The parties are married. The proposed party, that's author Jackson and India McSwain, are married, have been married for many years. They own jointly Crunch under the Detroit Municipal Code's definition of owner, which is section 6-1-2. They are both owners of Crunch. So India McSwain comes here on a criminal case to have Crunch put down or euthanized. My client is interested in regards to, as the state would perform something like this, the civil forfeiture, because Crunch is property. And in this case, the city is attempting to take that property or euthanize Crunch. So author Jackson's argument is, I'm an owner of Crunch. I hadn't been notified of this. I haven't been a party to either proceeding. So in order to euthanize, there's got to be two incidents with a dog bite. In this type of case, there was a prior incident that author Jackson was not party to, and in order to euthanize, there's got to be both. So I know it's confusing, but the argument on behalf of Jackson is, hey, I'm an owner. I'm sorry. Go ahead. I'm sorry.
Well, it's not confusing what you're stating. What's confusing to me is a case that's probably going on a year at now in an interested party. Suddenly, the dog hasn't lived with him. He hasn't been, because I know the dog was taken to a facility someplace, I don't know where, for someone who is capable and skilled in handling dogs that have shown a propensity for being dangerous. And so if he and the initial defendant are married, and I'm just wondering, where has he been for the last number of months?
Oh, Your Honor, if I
Right.
could briefly address that, I did highlight to the court and tried to bring him in through Miss McSwain, and the court denied that. That was roughly in March of 2023. So he's been there, and I've highlighted that to the city on numerous occasions, but they've fought me on that. And I think it's because they don't have the first administrative hearing against him. There's other issues there, but just to remind the court, Your Honor.
To break that down real quick, in the past, Ms. McSwain received some kind of violation for the dog biting someone. It went through the court process. It was documented. It was only under her name. In order to have a dog euthanized, you have to have 2 documented incidents under that owner's name. They're trying to find a loophole that says, well, if we bring this other person in, he doesn't have that first documented incident, so there's only one, so you can't euthanize him.
Okay, this has been going on for a long time, and I certainly don't remember at this time that there was somebody else who was coming in to be claiming to be an owner, and I would have denied that. But if you say that's what occurred, I'm not going to argue that. So certainly we are where we are today. So.
So the court, I think, sees you see the issues, and he's just asking to have his due process rights, that he would have in this property. And it's our understanding under the law that all parties that own property must be notified, must be part of the proceedings. He isn't or hasn't been and now wants to be. And I think he should be. But I also think,
which means he also opens himself up for any lawsuits that might be claimed for any injury that his dog has provided. I certainly don't have a problem with it, but I certainly kind of question why somebody would be putting themselves in a position that we're not there, where somebody who's suing the dog owner for a bite and for medical injury or distress or anything else someone might come up with for a reason to claim a dog owner.
And I think that just goes to show, Judge, how much he loves and cherishes the dog and wants to be part of this, regardless of potential civil liability. So he's an owner. He wants to be seen as an owner and wants whatever he can do to protect the dog.
Interestingly, on 10/14, the same day that Miss McSwain received her citations, Mr. McSwain also received quite a few citations, 7 to be exact, 4 tether violations, failure to vaccinate, failure to register, and an animal cruelty for failure to provide water, shelter, sanitation, medical, or food for the animal. Sounds like a loving owner.
All right, Attorney Rogers.
Yes, thank you. The city is objecting to Mr. Jackson being added as a party to this matter. As the court has said, this matter has been going on for a long time. I filed my motion for the dangerous dog hearing and to euthanize the dog over a year ago at this point. The motion has been pending this whole time because defense had motions. We transported the dog. There's been a lot of procedures going on in between. Mr. Jackson had that entire time to intervene. And also, Mr. Jackson has never asserted himself to Detroit Animal Care and Control as the owner of this dog. Only Miss McSwan ever has. That's why she is the named defendant here. And that is why she's the only one included on this. In June of 2020, there was a dangerous dog checklist that only Miss McSwan signed, saying that she understood the conditions that Crunch had to live under to be at the home after the first bite. No other owner is on that. At one point, she did attempt to get the dog license. It's only under her name. And then when the dog was deemed dangerous in October of 2022, once again, it was only addressed to Miss McSwan, and she was the only one that signed for it. The city was not aware of Mr. Jackson asserting himself as the owner of Crunch in particular. Mr. Jackson does have his own criminal cases also involving dogs, but these were different dogs. Same property, but different location or different dogs. He made assertions to Detroit Animal Care and Control that he did not own Crunch, and that is why only Miss McSwan is the named person here. And also, we aren't dealing with a civil forfeiture. This is a criminal case under a criminal case number, and this is a motion that is being heard under that criminal case number to euthanize a dog per the City of Detroit ordinances that allow that. We ask that this hearing move forward on October 26th. To hear testimony if Crunch should be euthanized per the city's motion that has been pending for almost a year.
Okay. So, Attorney Draper, tell me why I should do anything today that might delay or anything involved in this case where we cannot say your client did not know about this. I can only say the only people that did not know it is the City of Detroit and the prosecution. There has been nothing that has come up. Certainly, there would have been nothing that would have stopped your client from coming forward at any point saying, "Hey, I am a owner of the dog." There is nothing that he's come forward and saying, "Here's some paperwork where I purchased the dog." Simply saying, "Well, by virtue of Miss McSwain being my wife, therefore I am the part owner of the dog." I don't know that is just going to fly with this kind of where there is notice for over a year or at least a year that this case has been going on, but there's been no effort to claim any type of part of it. Quite frankly, I'm not sure why that would even is being done. And I think your client has slept on this too long, sir, and I see no reason to allow him to intervene and be a party of this case at this point.
Thank you, Your Honor. I understand the delay argument, and I apologize. It's not the intent to slow down the process or justice, and I appreciate the court's position. understand that argument of the city and the court, of course. So is that a ruling, or how should I, whatever?
That is a rule. So if he had some reason where he wanted to be heard on this case, like I said, this is not like, oh, somebody else was involved. This is my wife. I've not heard anything today that said that they were separated and this information was kept for him, and he, he's now aware of it and he wants to be a part, and he wants to be part of the fight to protect his property. I have nothing that just says, well, I'm not doing anything until the 12th hour, and I'm going to want to intervene as a party in this case. No, this is late. People had no notice of it, and I'm not sure exactly what the purpose and how it went, but I'm not going to allow him to join in at this point in time.
Thank you, Your Honor. And I'm not going to make representations to the court that I don't know to be true. I can't do that, obviously. So I would accept, thank you for the court's ruling.
Okay,
Thank you.
Okay, if I could just add to the record, Your Honor, I included, the city had absolute notice. Mr. Jackson is on the police reports. And I, on my motion dated December 9th, 2022, informed them of author Jackson's ownership. And the reason they fought it, and it's just for the record, Your Honor, last point, is they fought it is because they have no administrative determination, which is time barred by the statute of limitations against Mr. Jackson. And the records replete, they knew he was an owner. Thank you, Judge.
Ms. Rogers?
The city was aware of Mr. Jackson, that he was at the property, owned dogs at the property, but the city was not aware that Mr. Jackson owned Crunch. He asserted himself as the owner of, I believe, 4 other dogs at the property, not Crunch. Miss McSwan only inserted herself as the owner of Crunch.
Your Honor, the records don't reflect that, but.
All right. I've ruled on that matter. So, we've
Thank you
had.
very much, Your Honor. Thank you, counsel. Everyone have
Thank
an
you,
excellent
Judge.
day.
Thank you.
Thank you, Judge.
No, just additional on the record, we've been to court maybe 6 times on this matter, and this is the first I've heard of Mr. Arthur Jackson. So, all right, court ruling stands. Now.
Thank you, Your Honor.
Your Honor,
right.
last thing, if we can have a moment, this is not on the motion. Miss Rogers and I got her witness exhibit list yesterday. She'll have mine today. They're due today. I also had in a note that you may want a trial brief, but Miss Rogers wasn't sure, and I wanted to make sure. I may have misunderstood. Did the court want us to file trial briefs as well?
That would be helpful, yes.
Okay, and when would the court like the trial briefs?
Do we have a trial date yet?
That's 2
I don't
weeks
remember.
today.
Well, so we do have a trial date. I believe it's in February, but we have a dangerous dog motion hearing on October 26th.
That's a trial, Judge. This is a civil forfeiture action.
It is not a civil forfeiture action. It's a motion hearing. This is a criminal case.
It has to be Judge, the process is a civil forfeiture, but it's neither here nor there. We have it for the 26th.
All right, the 26th of
October.
Okay. I need how much time do you need to submit the brief?
If I mean, I could do it next week, Judge, if that works for Ms. Rogers, maybe by next Thursday, so that it would give the court a week, if that's enough time for the court.
Actually, unless it's 400 pages, I just need it the day before.
It won't be, mine won't be.
If I could have mine in the week of the 23rd, I start a jury trial next week. So next week I'm going to be a little jammed up.
And that would be fine with me, Judge, just so.
That's fine. I don't want to stress you. Long as I have it a day or two before you're going to be arguing, that's all I really need. So
I do have a question on what the issue that needs to be briefed.
counsel, if quite frankly, I think I pretty much know the case, so I'm not really sure that I actually need a brief, but if sometimes the attorneys like to submit one so they can outline their argument clearly and then just kind of refer to that when they're doing their argument as opposed to just doing it all in before the court. That's kind of up to you. I'm kind of flexible.
Okay, the people have essentially already done that in our motion here, our filed motion on that wasn't heard yet. So I believe the people will not need to brief anything additional.
There's nothing additional that needs to be said, counsel. That's kind of up to you now. If there's something that you want to highlight and, put in red, bold, with stars around it for me to see, that's kind of up to you.
Okay, Your Honor. So optional, and then if I'll file it on October the 24th, 2 days before the hearing, if I decide to do that.
That would be fine, because then if Ms. Rogers wants to look at it and say, hey, you know what, I kind of want to respond to this, you'll have time to do so.
Okay.
Great,
Fair
thank you.
Thank you, Your Honor.
And I have
Thank you.
one more question. Is this a Zoom hearing or in person on the 26th?
I'm requesting an in-person, Your
Okay,
Honor.
I couldn't remember.
You're requesting in person, we certainly will do that. You have that right to do so.
Thank you, Judge.
Thank you, Your Honor.
Thank you, counsel. Madam Clerk,
Hmm.
we're gonna have this in person on, do you know what our 26 looks like?
Your Honor, can I exit with all due respect since I'm not party? Is that okay?
Yes, sir.
Okay. Thank you so much. And thanks to your staff.
Um,
All right.
It's already scheduled for the 26th. I just don't remember whether, I have to check it now and see what that originally scheduled for in person. I don't know if that's what we originally agreed upon, but I'm about to check.
But the docket isn't big that day. So
No, I mean, it was.
no,
already
that's
on
fine. I'll let them do it now in person.
Yeah, it's scheduled for the first one. Well, no, wait. The motion hearing wasn't, but that's fine.
And that's a Thursday.
Yeah.
Okay. All right. We're good. We can do this in person on the 26th.
Okay.
And what time is it at?
That's
Let's do 10 o'clock, because hopefully we'll be finished with our morning docket by then.
10 a.m.
Works for the
Thank you.
people.
Yep, 10
That good
a.m.
with you?
Sorry.
Thank you. Well, I'll get to see you in person, counsel. So we'll see you on that day.
Sounds good. Thank you very much.
All right. See everyone on the 26th. I'm sure I'll talk to you before then, Miss Dunn.
Okay, sounds good, Ms.
All right. Thank you.
All right, thank you, everybody. Have a good day.
All right. See you guys. Have a good one. See you tomorrow.